Good afternoon, everyone, and welcome to the final panel in the Conrad E. Wright Research Conference this year. The 2020 conference shall not be denied, the 15th and 19th Amendments at the Sesquicentennial and Centennial of their ratifications. We've had a wonderful week of panels and papers, and we're happy to have this final one and then the concluding remarks or the concluding conversation, which we certainly hope that you will be part of as well. My name is Kenneth Wall-Street Channelai. I am the Director of Research at the Massachusetts Historical Society. Our first presenter today is Dr. Adam Domby. He is an historian of the Civil War, Reconstruction, and the American South. He is an assistant professor at the College of Charleston, and his book, The False Cause, Fraud, Fabrication, and White Supremacy in Confederate Memory, can be ordered from your favorite bookseller. It examines the ties between lies, white supremacy, Confederate monuments, how we recall the past. In addition to Civil War memory, he also works on issues of prisoners of war, guerrilla warfare, Reconstruction, divided communities, as well as public history. Professor Domby, welcome to the MHS.
Thank you so much for that kind introduction. I'm really glad to be here, and I want to thank so much the Massachusetts Historical Society, my fellow panelists, and all of you for being here. And I'm going to speak today about how the 15th Amendment, as well as the 14th Amendment, really, were recalled at the passage of the 19th. And I'm excited to see what folks think as this connection between Civil War memory and suffrage is sort of new research I'm doing, and I'm still sort of processing as I finished my first book on Civil War memory, and I'm now sort of growing it in other directions. And so I want to start, though, at a mass meeting in Montgomery, Alabama in the summer of 1919, when 4 lawyers spoke out against the 19th Amendment that would, of course, provide women the right to vote. They termed the proposed suffrage amendment, and I quote, "the blood brother of the 14th and 15th Amendments to the organic law of the nation, both of which were conceived in inequity and born in sin based on hatred and the frenzied desire of carpetbagger scalawaggery, dominated by the most depraved considerations for racial equality," which is something that the number of sort of times where the cognitive dissonance hits you there is pretty high. But here we have an attempt to stop the 19th Amendment, right, by appealing to a memory of the past. As another speaker noted, it was inconceivable that the Alabama legislature would want to bring back the days of 1870 to 1880. Again and again, as states debated the 19th Amendment, those opposed to this amendment pointed to the 15th and 14th Amendments and the supposed failure of black enfranchisement as a reason to oppose ratification. Now, ratified in 1868 and 1870, respectively, the 14th and 15th Amendments, of course, were crucial. The 14th provided equal protection under the law regardless of race, and the 15th protected African Americans' rights to vote. These are two of the most important legal outcomes of the Civil War, I would argue. And throughout the Jim Crow era and into the present, white Southerners have grounded their legal defense of efforts to disenfranchise black voters by championing the principle of states retaining sovereignty over local issues, states' rights. Indeed, during the Jim Crow era, white Southerners often conveniently ignored the fact that the 15th and 14th Amendments expanded federal jurisdiction. Now, at the same time, a lost cause narrative of history, which we're going to discuss in a moment, served as a call to arms for white Southerners to provide united resistance to federal intrusion into state affairs, as they might have said. Most frequently, they did this, of course, when race played a role. And states' rights frequently in many ways remains a dog whistle for white supremacy. Not always, but frequently. It is no coincidence that those opposed to the civil rights movement in the 1950s and 60s frequently argued against federal intervention as being illegal, and as the matters at hand were state issues because they didn't want to lose control of their state and have to share power with non-white Southerners. Indeed, those seeking to limit the federal government's efforts to protect both civil and voting rights still often focus on the importance of states' rights when downplaying how the 14th and 15th Amendments expanded federal jurisdiction. Now, white Southerners opposed to giving white women the vote mobilized fears of black voters again and again by reminding voters of Reconstruction and how African American men had voted freely during that era. Now, frequently, these anti-suffragists argued the 19th would lead to black voters and thus would lead to violence. As one speaker at the mass meeting recounted, There would be bloodshed, nay, Negro extermination in the South if the purveyors of this amendment, which was only a cloak to break down white supremacy, forced this upon a people who did not want it and would not stand for it. Now, this was not a new tactic, I should point out. When white Southerners compared the 19th Amendment to the 15th, they were playing upon a fabricated memory of Reconstruction that portrayed the period after the Civil War inaccurately and had long been used to justify disenfranchised black voters. Many of you may be familiar with aspects of the Lost Cause. And this is what I write about in my book, The False Cause. It's the memory of the war that many Confederate veterans pushed after the war. And as my book details, it's a narrative that helped justify Jim Crow through this fabricated narrative. Among the ways the past was rewritten, including remembering the war as being about states' rights, even though we know that slavery had been the war's central cause. And indeed, former Confederates frequently recalled themselves as the greatest warriors despite the war's outcome as well. Again and again, you find these elements about how the war was remembered that were more about the present than the past. But the memory of the Lost Cause wasn't just about the war. In the early 20th century, white Southerners portrayed the antebellum era of one of pleasant race relations, ignoring the horrors and terrors of slavery. Now, the reality, of course, we need to make sure to state, slavery was a horrible system premised upon the use of terror, violence, and family separation to extract labor. There's no defending it. But in this falsified memory of the past, slavery was benevolent, enslaved people were happy. Additionally, they also remembered Reconstruction as a period of misrule, of corruption, portraying the 15th Amendment, which again protected the right of African Americans to vote, as a mistake. This, despite the fact that Reconstruction was no more corrupt than any other period. And indeed, I would argue a good deal less corrupt than certain other times, which we can remain nameless. This fabricated memory of Reconstruction had already been used, though, to disenfranchise black men and justify Jim Crow. And I'll give you a few examples of this. In 1910, at the dedication of the Confederate monument in Monroe, North Carolina, Thomas Bickett used the memory of Confederate heroics to justify segregation and disenfranchisement of black North Carolinians. And so this is at a dedication to a Confederate monument. He declares in his keynote address, the 15th Amendment was the most colossal blunder and crime in the history of the civilized world. And he argued that Reconstruction had showed the world that the South and only the South is competent to deal with the race problem. Now, this appeal to allowing white Southerners and individual states to determine what happened in southern states, this appeal to states' rights, if you will, was fundamentally about who would be allowed to vote and who would be empowered. And so mobilizing memories of Reconstruction was a fear tactic that had been used previously against efforts to expand democracy. During the fusion movement in North Carolina in the 1890s, conservatives frequently pointed to Reconstruction and African American empowerment as a reason why whites needed to vote against this Republican populist fusion ticket, which had biracial support, and led them, these conservatives, to support a grandfather clause that would ensure one-party rule until the civil rights movement in North Carolina. By 1920, in the southern states, the 15th Amendment was essentially dead letter. It was not being enforced. African Americans were functionally not able to vote across the South. And I'll give you an example. In Alabama, 150,000 white voters were registered in 1910, while only about 3,000 black voters remained registered in the state. So despite the fact that the state was only 56.6% white, 98% of the electorate was white. Despite this overwhelming control of the ballot box, the 19th Amendment scared white Southerners, or we could see it as representing a tool to those opposed to women voting that they could use to garner votes. So whether we should take them at their word that they really did fear this or not remains up for interpretation, I would say. But these fears were at least portrayed at this Alabama meeting that I mentioned earlier, as that it might open up the door to federal interference once again. At the 1919 meeting, H.L. Brazil declared that the 15th Amendment was only sleeping, but with the ratification of the 19th Amendment, it could speedily become wide awake. And he feared the conditions of 1868 to 1880 would be lived through again. Ironically, he went on to claim that any Southern legislator who supported the amendment was untrue to the principles of democracy. And of course, the principles of democracy as he saw it are perhaps different than the principles of democracy as we understand them today. Now, the Lost Cause memory of the war erased slavery as the cause, substituting, of course, this historically inaccurate understanding of states' rights. Despite this, it did not indicate Southern conservatives' disavowal of white supremacy. Instead, they were really doing so to claim victory after the war. In 1900, arguments that states' rights were openly being deployed to justify disenfranchised black voters. This is not a subtle, hidden effort. This is an open, we are doing this to disenfranchise African Americans. They would say so. And in 1919 and 1920, it was being used to argue against women voting. There was no effort to hide the fact that this was about race and that states' rights was a central tenet of protecting white supremacy. Instead, this was an overt playing on fears that were probably knowingly exaggerated. In South Carolina, a man opposed suffrage because he feared it would take control away from the states, noted that states' rights, whose violent violation brought upon us all the horrors and easy for me to say, whose violation brought upon us all the horrors and abominations of these so-called Reconstruction. States' rights whose power enabled us to rescue government from barbarous Negroes and plundering carpetbaggers and to restore decent and civilized administration of affairs, end quote. In essence, he was celebrating the 15th Amendment going unenforced. Now, this South Carolinian, though, noted that in his sort of playing up of fears that enfranchising women would, quote, produce a majority of Negro voters over white voters in South Carolina. Now, he was ignoring an important fact, that according to the previous census, the state was majority black whether or not women were counted. The man asked, how shall we manage to prevent the majority from ruling the state? By force or by fraud? Clearly, the author felt these were legitimate options to be considered once again, as it had been in 1876, when Wade Hampton came back to power in South Carolina. And in some cases, though, it's worth noting that this willingness to accept racial violence could actually lead individuals to support voting rights for women. Julian Carr, who was the leading Confederate veteran in North Carolina and a central figure in my own research, unapologetically declared himself in favor of the 19th Amendment in 1920. And even as he did so, he sought to address the concerns of those fearing how this might influence black voting. And he explained, and I'll quote again, since the party has proven its ability to preserve white supremacy against the Negro male voter, I am content to risk the franchise in the hands of the females. Some of us, at least, have not gone anywhere since the perilous days of 1900 and claim to be doing business at the old stand and profess to know how. Now, this reference to 1900 was a clear hearkening back to violent white supremacist campaigns, including things like the Wilmington Race Massacre. And Carr was making clear that he felt the same tactics, the same appeals to white supremacy, the threats of violence, and if need be, the use of violence towards African Americans not only could be used, but would be used again if need be. And it should be noted that Carr himself participated in Klan violence in the 1860s. He supported racial violence again in 1900, and he was ready to advocate it again in the 1920s. And indeed, a few years later, he would join the Second Klan. So he had joined both the First and the Second Klan. So appeals to memory and a lost cause narrative of the past to keep women from voting went beyond the 15th Amendment. Brazil, at this meeting in Alabama, declared anyone who could vote to ratify it while remembering the deeds of their forefathers and on the field of Appomattox at Gettysburg and in the wilderness was betraying their ancestors. Now, once again, this was a repeat of an old tactic. Reminders of the valor of white men during the Civil War was a common refrain in arguments for white supremacy during efforts to institute Jim Crow. In 1900, Charles Aycock had declared that that white men had proven themselves at Gettysburg, when they had proven the superiority of the white men, and had been demonstrated, they demonstrated it during this war again and again, before he argued that a literacy requirement for blacks made sense because African Americans cannot gain suffrage from inheritance, unlike whites. Therefore, we say, that he went on, he must get it by education. Now, memories of the Civil War had been critical in arguments for disenfranchisement, and so it remained one going forward. Now, how effective was this race baiting and appeals to memory of Reconstruction? If we judge by the results, pretty effective. By 1923, all but 9 states had ratified the amendment. Maryland would be the first of those to ratify it in 1941. The other 8 were all in the former Confederacy. Mississippi would be the last holdout in 1984, just to give you an idea of how recently that is. White Southerners were not the only group, though, appealing to memories of the 15th Amendment. While conservative white Southerners opposed the 19th, decried it awakening the 15th, African Americans relished this prospect. Indeed, African Americans saw the potential to use the 19th Amendment to enforce the 15th. The Cleveland Gazette hoped that whites would be less quick to treat black women as poorly as they did black men, warning readers, to attempt to treat our women as our men have been is to court serious trouble. And of course, at the very least, it would mean in the North that black women could vote and potentially help influence national politics. Now, there's a very real connection between the Reconstruction Amendments and the 19th. The 14th Amendment provided for a reduction in representation for eligible voters who were disenfranchised. This is before the 15th is put in, of course, to try to be used as a threat that if you disenfranchise African Americans, you'll lose seats in the House and electoral college votes, right? Though never carried out, if they had carried it out, as some African Americans argued for, Southern states would have lost representation for denying black women and men the right to vote. The potential loss in seats would then increase if the 19th was passed. And with the 1920 census on the horizon, as these debates around the 19th were going on, this represented a real threat to white Southern power. As the Cleveland Gazette and this newspaper pointed out in 1919, the recurring 10-year period gives rise once more to the talk of cutting down Southern representation to meet the situation caused by the South's disenfranchisement of black Southerners. Now, if Republicans took control of the Congress and the presidency, which they did in 1921, they could have the potential to use that power in reapportionment. The NAACP even asked candidates in 1920 if they would support using the 14th Amendment to reduce representation and enforce the 15th. Now, those hoping for action to punish the South for disenfranchising its citizens were, of course, sadly disappointed, as Republicans failed to take away Southern states' seats, and although efforts were made to do so. And so I think it only appropriate to conclude by considering where we are today. Now, once again, we are faced with lies and racism and efforts to keep certain Americans from voting front and center. As the 2020 census wraps up, we are now on the cusp of another reapportionment. Perhaps it may be time to revisit the 14th Amendment's second clause. Should there be a contested vote next month, and state legislatures try to appoint a slate of electors, not chosen by the people, but by the state legislature to try to overturn the will of the voters in November, is there perhaps an argument for a penalty come 2021's reapportionment? Is it perhaps time to amend the 14th Amendment to include women and felony disenfranchisement as potentially penalizing with lost congressional seats? Would the threat of a loss of seats lead to a change in how Americans approach voting? Now, these are perhaps not historical questions, but as we deal today once again with increasing anti-democratic efforts by one party, perhaps the tools that earlier generations created to protect democracy might be worth more carefully examining, both for what worked and for what failed. Thank you guys for having me today.
Thank you very much, Professor Domby. Our next presenter is Professor Elizabeth Katz. She is an associate professor of law at Washington University in St. Louis. Professor Katz received her PhD in history from Harvard University and her BA, MA, and JD from the University of Virginia. She is a legal historian with expertise in family law, criminal law, and state legal systems. She is particularly interested in how gender and religion have influenced the development of doctrines and institutions in these areas. Her scholarship has been published in the Stanford Law Review, the University of Chicago Law Review, the Virginia Law Review, and the William and Mary Journal of Women and the Law. Her research has been supported most recently by the William Nelson Cromwell Foundation Early Career Scholar Fellowship, awarded by the American Society for Legal History, an Albert J. Beveridge Grant from the American Historical Association, and a fellowship from the Stanford Center for Law and History. Professor Katz, welcome to the MHS.
Thank you so much, Kid, and hello, everyone. First, I want to echo many panelists from earlier in the week in thanking the conference organizers for all of their hard work in converting this conference to the online format. I'm so pleased to be participating in this panel, which marks important anniversaries of two critical constitutional amendments. Today, I'll be focusing on the history of the 19th Amendment and my research on the related and understudied issue of women's legal right to hold public office. The 19th Amendment, which was ratified in 1920, reads, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Note that the amendment does not say anything about office holding. Still, many scholars and commenters have claimed or assumed that the right to vote and hold office necessarily came together. However, as I'll explain, in women's legal history, these twin rights have often been separated. Relatedly, the 19th Amendment scholars have suggested that women rarely sought or obtained public office prior to the 19th Amendment, yet we'll see that this is also not the case. Women began organizing to demand social, legal, and political changes pertinent to women's status in the 1830s and 1840s. Women's movement leaders demanded changes to family law and rules governing marital property ownership, as well as access to the profession and other social changes. While all of their demands were controversial, women's pursuit of political rights, the right to vote and hold office, seemed especially radical. In these decades, states had full discretion over voter and office holder qualifications. It was common for state constitutions to contain restrictions on both voting and office holding based on sex, race, length of residence, age, and other factors. It was also common that state constitutions would state that only electors could hold public office. This meant that limits on electors simultaneously restrained both voting and office holding, and often restricted access to even low-level and appointed public offices. Here's just one example from the mid-19th century to make that more concrete. This is from Ohio's Constitution as amended in 1851. In the first provision, we see that only white male citizens who met certain requirements were electors. And in the second, we see that no person could be appointed or elected to any office unless he was an elector. In constitutions like Ohio's, suffrage and office holding were directly linked. And even in states where the language was not as clear as in the Ohio example, many people understood voting and office holding as obviously paired, even if not identical, the flip sides of the same political coin. Women's suffrage leaders sought the ballot more frequently and vocally than the right to hold office, but they understood that these rights were connected and they wanted both. For instance, in 1850, Elizabeth Cady Stanton wrote a letter to a women's rights convention that addressed this exact issue. Anticipating a key anti-suffragist argument, the letter read in part, "But if woman votes, would you have her hold office? Most certainly would we have women hold office. We would have man and woman, what God intended they should be, companions for each other, always together, in council, government, and every department of industry." And anti-suffragists, of course, were not persuaded. They routinely pointed to the seeming horror of women holding office to argue against even allowing women to vote, in addition to many other arguments historians have frequently discussed. Voting was bad enough, anti-suffragists argued, but if women hold office, they'll become unmanly, abandon their homes, and in the language of the time, unsex themselves. It's also clear in many of the historical examples that some men were worried about the extra competition women would bring if they were declared eligible to hold office as well. Suffragist responses ranged from Stanton's bold and unapologetic statement to gentler and more strategic claims. Some attempted to reassure naysayers that very few women would actually seek office, or that they would limit themselves to gender-appropriate offices like school superintendent. Both sides incorporated office-holding arguments into their advocacy from the mid-19th century into the 19 teens. During debate over the Reconstruction Amendments after the Civil War, women's movement leaders became became even more focused on political rights, somewhat narrowing from the broader reform agenda of earlier years. Some suffragists believed the opportunity was ripe for securing women's political rights alongside Black men's, and pressed for legal changes at both the state and federal levels. In their advocacy, proponents of women's suffrage did not emphasize office holding, likely recognizing it would harm their chances of obtaining suffrage. But still, they clearly had office holding in mind, as is demonstrated by a number of their writings and speeches from the period. After Congress passed the 14th Amendment, which incorporated the word male into the U.S. Constitution for the first time, Elizabeth Cady Stanton offered perhaps the most visible indication of women's interest in office holding. She announced her highly symbolic candidacy for Congress, the first woman to ever run for Congress. Because the U.S. Constitution did not explicitly limit congressional seats to men or to electors, she presumably was eligible. She pledged that if elected, she would demand universal suffrage to secure a Republican form of government for every state in the Union. But of course, she did not win. And the 15th Amendment, passed a couple years later, forbade discrimination in voting on the basis of race, color, or previous condition of servitude, but not sex. After women's exclusion from the 15th Amendment, many women's suffrage leaders began pressing for their own amendment, then envisioned as the 16th. Others thought the best path forward was state-level constitutional amendments. The state-level approach saw the first successes. In 1869, Wyoming Territory became the first jurisdiction to fully enfranchise women. The constitutional provision there explicitly guaranteed both suffrage and office holding without regard to sex. The following year, newspapers across the country hailed the appointment of 2 women as justices of the peace. These were the first 2 women to hold judicial offices in the United States. As depicted in this frequently circulated image, the general pattern over the following decades was that women's suffrage spread from west to east for reasons including demographics, intersections with other reform movements, political alliances, racial politics, and much more. By the mid-19 teens, almost every Western state granted women full suffrage. Like Wyoming, many of these Western states explicitly granted women equal suffrage and office holding in these constitutional amendments. For that reason, office holding somewhat followed the same regional pattern as suffrage. But in other states, women were permitted to hold at least some offices before they were enfranchised. This was authorized mostly through a mix of state constitutional amendments and litigation. Dozens of cases reached state Supreme Courts asking whether women could serve as justices of the peace, notaries public, county clerks, city prosecutors, and much more. In the Northeast, the judiciary was deeply conservative and routinely held that women could not hold public office because the framers of state constitutions hadn't envisioned that women would do so. For instance, in one of the earliest and most influential cases in 1871, the Massachusetts Supreme Court held that the governor did not have the power to appoint prominent suffragist Julia Ward Howe to serve as a justice of the peace. In the single paragraph opinion, the court justified its holding on the basis that excluding women from the position was supported by, quote, the law of Massachusetts at the time of the adoption of the Constitution, the whole frame and purport of the instrument itself, and the universal understanding and unbroken practical construction for the greater part of a century afterwards. Massachusetts history, rather than specific legal text, stood in women's way. Because of decisions like these, a constitutional amendment would be necessary for women to hold most offices in many northeastern states, and especially in New England. And though suffragists pursued limited amendments focused on office holding, for instance, amendments to allow women just to be notaries public, male legislators and voters usually rejected these proposals. These rejections were high stakes because they were perceived as indicating public opinion on women's suffrage as well. Meanwhile, the Midwest developed into an interesting middle ground. Though women could not vote, they nevertheless were permitted to hold many offices, including elected offices. For example, we can look to Missouri, where I am right now at WashU in St. Louis. In 1870, the Missouri governor appointed the state's first woman officer, a notary public. This milestone was covered in the press, which praised the advocacy of St. Louis's suffragists. It doesn't seem anyone challenged the appointment as legally invalid, and as this slide suggests, many other women were appointed as notaries in the following years. In 1872, a Missouri woman was permitted to hold the elected office of County Recorder of Deeds, though she could not vote for the office herself. And again, there doesn't seem to have been a legal challenge. The issue of women's legal eligibility to hold office first reached the Missouri Supreme Court in 1897, after a woman was elected as a county clerk. The man who lost the election sued to challenge her right to take the post. And that was a common way these kinds of cases arose, when a man did not want to accept that a woman had received more votes than he did for a position. In that case, the Missouri Supreme Court concluded that women could hold any office unless there was an explicit legal carve-out in the state's laws. The judges were unwilling to exclude women from office holding based on the state constitution's silence or the use of male pronouns, two common moves made by judges in the Northeast. Over the following decades, piecemeal consideration of women's office holding continued and largely followed the pattern I've described. Office holding was available to women in the West, extremely restricted in the Northeast as well as the South, and a mix in the Midwest. This leads us up to the years immediately before the successful ratification of the 19th Amendment. We see that many women could already vote and hold office before the federal amendment. And in fact, women's increasing political power was a significant part of the momentum and pressure that finally led Congress to pass the law. Importantly, the 19th Amendment did not guarantee all women the right to vote. Rather, it forbade discrimination in suffrage on the basis of sex. So women of color and others still had to fight for their right to the ballot. Another facet of women's rights that the 19th Amendment did not solve was whether women had the legal right to hold public office. It was unclear to many people whether the 19th Amendment actually guaranteed the right to hold office as a legal matter. Here's a representative headline. Women hold office, lawyers are puzzled. There were several reasons for this uncertainty. People recalled that the 15th Amendment hadn't seemed to secure Black men's office holding. Rather, after the 15th Amendment was passed, many Southern states had been forced to protect Black men's office holding in their state constitutions as a condition for re-entry into the Union. This seemed to imply that the 15th Amendment itself did not extend to office holding. And since the language of the 19th Amendment was modeled on the 15th, it seemed the same result should follow for women. People also recognized that in order for women to hold office, many state constitutional amendments had expressly included office holding. Again, this seemed to suggest that office holding was not implied by suffrage. Consequently, people reasoned that the 19th Amendment, which only referenced suffrage, might mean only suffrage. To return to the Missouri example one more time, legislators here were among those who were puzzled or skeptical about the scope of the amendment. Many did not think the 19th Amendment was enough to overcome state laws that limited some offices to men. Instead, they thought it was necessary to pass a state constitutional amendment. And Missouri voters passed this amendment by a narrow margin in 1921. Likewise, most states permitted women to hold office by the mid-1920s, either because of amendments, court cases, or attorneys' general opinions. Litigation and amendments continued in a handful of states beyond the 1920s. For example, it was only in 1943 that women in Oklahoma were permitted to hold the highest state offices, including governor. And still, questions lingered even after that. I'll close with one particularly remarkable example. This is from a document I found in the National Archives, written in 1953 by then Secretary of State John Foster Dulles. The portion in the image reads, "It is, I imagine, at least debatable whether under our Constitution a woman can be president." I'll close there, so thanks again to the conference organizers, and I look forward to our discussion.
Thank you very much, Professor Katz. Our commenter today is Professor Akhil Amar. He's the Sterling Professor of Law and Political Science at Yale Law School. An authority in constitutional law, he has won Yale College's 2008 Devane Medal and the American Bar Foundation's 2017 Outstanding Scholar Award. He also received the American Bar Association's 2006 Silver Gavel Award for his book, America's Constitution, a Biography. He is the author of many other books and articles, and his work has been cited in over 36 Supreme Court cases. He most recently published The Law of the Land, a grand tour of our constitutional republic, and The Constitution Today, Timeless Lessons for the Issues of Our Era. His forthcoming book is titled The Words That Made Us, America's Constitutional Conversation, 1760 to 1840. That comes out next year in 2021. Professor Amar, welcome to the MHS.
Such an honor to be with you. I love these papers. We need to have more conversation between historians and law types. I've been plowing in the fields that Adam and Elizabeth have been exploring for many years, and so I'm going to try to, this is perhaps bad form on my part, but plug what I've written because I think it's going to be very helpful for both Elizabeth and Adam. It may be even more helpful than they've yet discovered, because the little pieces are here and there and everywhere, and I want to try to pull them together. And speaking of little pieces here and there and everywhere that need to be pulled together, the Constitution is filled with clauses, and we have to actually, the little pieces, we have to actually read them together. This is, some people call this intratextualism, reading one provision of the Constitution again in connection with another. Today, for example, no fewer than 5 provisions of the Constitution use the phrase, the right to vote. 14th Amendment, Section 2, all about apportionment. 15th Amendment, Section 1, about black voting, black suffrage. 19th Amendment, Section 1, about the voting on grounds of sex. The 24th and the 26th Amendment about poll tax, disfranchisement, and young adult voting, respectively. So how do these 5 different clauses that talk about the right to vote, how should they be read? Should they be read in connection with each other? Adam in particular is interested in, and so is Elizabeth, the connections between the 15th Amendment and the 19th Amendment, and they're obvious when you read the text. I'm going to emphasize certain words in my dramatic reading. The right, this is the 15th, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Again, no, with emphasis. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of, and then race, color, previous condition of servitude. Now the 19th Amendment. The right of the citizens of the United States to vote shall not be denied or abridged by the United States on account of, or by any state, on account of sex. So the 19th Amendment is just the 15th Amendment, but substituting the word sex for race, color, and previous condition of servitude. So of course, these things need to be thought about together. And of course, people who oppose the 15th Amendment in the Deep South are going to oppose, many of them, the 19th Amendment for similar reasons. And Section 2 of these amendments are going to be in the same words, in hac verba, a lawyer would say. Okay, so much for intratextualism. Now I'm going to talk about intertextualism and how you have to read sometimes provisions of the Constitution alongside other legal texts. So Elizabeth mentions that the 15th Amendment says right to vote and doesn't say right to hold public office. But here's the backstory. Both the House and the Senate versions talked about the right to hold public office. They disagreed on some other things, but not about that. They said right to vote and hold public office. It goes into a committee, and when the committee comes out, ordinarily committees split the difference, but here the committee takes out what was in both the House and the Senate version. So what's up with that? Well, some people, I think the wrong people, say they meant to actually exclude the right to hold office. They meant not to include it. That was purposeful. Not so. The work of Vikram David Amar, who from time to time is also my younger brother, Yale Law School graduate, Supreme Court clerk, dean of the University of Illinois College of Law, proves conclusively in an article, Elizabeth cites it, but could use it even more, I think, than she has. Jury service is political participation akin to voting. I'm talking about public office holding, but I'm going to get to jury service soon enough. He shows that here's the backstory. Congress told various states, you can come back into the Union on the following conditions, Confederate states. You have to ratify the 14th Amendment, you have to let black people vote. And Georgia says, okay, we'll do that. Georgia then prevents black people from holding office. They say, oh, you have a right to vote, but you don't have a right to be voted for. You have a right to vote, but not a right to vote in the legislature. And Congress says, nice try, but no. You've broken your word. The right to vote impliedly included the right to be voted for, the right of blacks to vote for blacks, right to vote in a legislature as well as for a legislature. Of course, you'd have a right to vote, obviously, not just for representatives, but in an initiative or referendum, and that's lawmaking, so why not in the legislature itself? So the right to vote without more includes the right to be voted for, the right of blacks to vote for blacks, the right to vote on a law or in a legislature. That's the position that Congress took, and they threw Georgia back out, and everyone in the world saw that. Now, if at the same time they're proposing a 15th Amendment, if they say the right to vote and to hold office, they're conceding that actually you need to say and hold office, that that's not otherwise implicit in the right to vote, and they don't want to concede that, because they want to say intertextually, we have this other rule and Georgia violated it. It promised it was going to let black people vote, and it violated it by not letting black people vote for black people, by not letting black people vote in a legislature, not letting black people be voted for. So that's why they took it out, and Vic has conclusive evidence on this, and Mike Harmon, my friend, gets it wrong, and Earl Maltz, my friend, gets it wrong, and that's the deep background in history, and that's actually in the autobiography of one of the key conferees, Senator Stewart. That's the 15th Amendment, and it already includes the right to hold office. Now, what about the right to serve on a jury? Well, these things are connected in the minds of many folks, as has been said, but I want to say it's already in the Constitution. Gandhi was once asked what he thought about Western civilization. And he paused and he said, I think it would be a good idea. And he meant, actually, you're supposed to already have it. The right to vote, I take the position, without more, unless you specify otherwise, generally includes the right to vote on a jury, because that's what jurors do, or in tandem with laws that say voters are generally jurors. And those laws exist in many states, and Tocqueville has talked about this long before the Reconstruction period. The right to vote without more generally encompasses the right to vote on a jury, the right to vote in a legislature, and the right to hold office. Now, is this just Akhil Amar's theory? No, it is not. It is the Congress of the United States, and this is actually more inter and intratextualism. This is from my book, America's Constitution, which was kindly plugged, page 400 to 401. Here's the statute that Congress passes. It's an act of 1875. It's still on the books today, and I'm going to read you the key language. Here's the language of the statute. 1875 Congress. No citizen shall be disqualified for service as a grand or petit juror in any court of the United States on account of race, color, or previous condition of servitude. Now I'm going to read it with emphasis, and I'm going to emphasize, because what clause of the Constitution authorizes Congress to pass that? My claim is not the 13th Amendment, not the Equal Protection Clause of the 14th Amendment, not the Citizenship Clause of the 14th Amendment, not the Privileges or Immunities Clause of the 14th Amendment. It's the 15th Amendment, word for word for word for word, 15 times. Okay, here's the language of statute, and then with emphasis, and here's the language of the 15th Amendment. Here's the statute. No citizen shall be disqualified for service as a grand or petit juror in any court of the United States or of any state on account of race, color, or previous condition of servitude. Here's language of the 15th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Congress clearly understands that voting is connected to jury service, and the Supreme Court actually finally says stuff like that in Neal versus Delaware, which is cited in footnote 777 of Elizabeth's manuscript in passing, but not, I think you should make way more of that. And the 15th Amendment is understood by the Reconstruction Congress itself as being about jury service and holding office. And the Supreme Court eventually sees that in Neal versus Delaware, an opinion by John Marshall Harlan. That's John freaking Marshall Harlan to you all, the great dissenter in Plessy versus Ferguson, and he's the man. So if that's all true of the 15th Amendment, why isn't it equally true of the 19th Amendment? Because the 19th Amendment is just word for word for word, the 15th Amendment is substituting sex for race. And people say just that. A leading anti-suffragist a leading cartoon, this is from 1915, when the 19th Amendment is just being discussed. It's a spectacular cartoon, and it says, "Women are too sentimental for jury duty," anti-suffrage argument. So the suffrage debate, people understand, is about not just voting, but voting on juries, just as it was for blacks in the 15th Amendment debate. And Neal versus Delaware, and there's actually a Georgia case that says the same thing, by the way, Georgia State Supreme Court case. The best short story of 1917 is by Susan Glaspell. It's turned into a Broadway play, wins a Pulitzer. It's called A Jury of Her Peers. And if you haven't read it, read it. It's online. It's amazing. It's short. It's as good as any O. Henry story you will ever read. And A Jury of Her Peers is obviously about women's suffrage in 1917. So I take the position that Western civilization would be a good idea. We already have it. The Supreme Court never quite said this. Even in Taylor versus Louisiana, when women finally are brought onto jury service, the 19th Amendment is not featured front and center, and that's in the 1970s. But I can tell you that in about half the states, state judges do use state constitutional equivalents of the 19th Amendment to recognize a right of women to be voted for, to hold office, and or to serve on juries, just on the basis of the state's 19th Amendment equivalents, and standing alone, and or in combination with pre-existing state laws and traditions that say generally voters are eligible to serve on juries. So I have a huge endnote in my America's Constitution, a biography book. I want to make sure that Elizabeth and everyone else in the audience knows about it, because it took me a long time to pull together this data. And once one person has done it, it's available to the rest of you all to use it. It's EndNote 51 at page 619. And here's actually how it's introduced in the text of the book. The text of the book says the following at page 426 to 427 of America's Constitution, a biography. Even if the 19th Amendment did not by itself make women equal jurors, didn't it do so in tandem with state laws and practices linking jury service to suffrage rules? Many state Supreme Courts and state legislatures in the progressive era construed the 19th Amendment and or its state constitutional counterparts to have precisely this effect, though other states failed to see the light. More broadly, the amendment's implicit logic undercut many of the old justifications for keeping women out of the halls of power. For example, any argument that women could be kept off juries because they lack sufficient capacity to make important decisions would seem to be refuted by the 19th Amendment itself. Since the amendment empowered women to vote as equals for constitutional conventions and for presidents, it plainly presupposed that women did indeed have the right stuff to be equal partners in all serious matters of governance. And then go on in this book, America's Constitution, and in this book, America's Unwritten Constitution, to say, of course, the 19th Amendment means that women are eligible to be president, and more than that, that no state could lawfully exclude women from the presidential or vice presidential ballot. Now, here's the end note, where I give you, the reader, and it took a long time to pull together, all the state court decisions on one side and all the state court decisions on the other side. So I'm just going to, just briefly, and then I'll end here. Just tell you the states. For progressive era state constitutional, state court decisions, holding women eligible to serve in juries and or hold certain other public offices as a result of their state or federal constitutional right to vote by itself or in tandem with prior state laws and customs, C, and then a Nevada case from 1918, a Montana case from 1919, a Michigan case from 1920, a Maine case from 1921, a Pennsylvania case from 1921, an Iowa case from 1921, a Massachusetts case from 1922, a North Carolina case from 1922, a Texas case from 1924, an Indiana case from 1926, a New Hampshire case from 1927, an Ohio case from 1929. That's on the one side. These are the judges who get it. Then there are obviously people who don't. 4 more narrow readings in the early 1920s, and then I cite a Massachusetts case from 1921, a Texas case from 1921, a Louisiana case from 1923, an Idaho case from 1924, an Illinois case from 1925, and then I go on to this one final set of categories for broad recognition by state legislatures of the spirit of the 19th Amendment and counterpart state constitutions, C, and then I tell you statutes from California, from Maine, from New Jersey, from Wisconsin, from Minnesota, and elsewhere. And I'm just highlighting this because I promise you it took me a long time to pull all that together. It wasn't pulled together before I came along. It's available to all the legal folks and all the history folks, and we need to talk to each other, I think, more than we do. So just to conclude, here are some textual arguments. You know, jurors vote, and historically, voters have served on juries. And people in legislatures are voting, and the right to vote without more means a right to be voted for. If blacks have a right to vote, they have a right to vote for blacks. The 14th Amendment, Section 1, is about civil rights, but the 15th and 19th Amendment are a broader category of political rights. And Congress has recognized this in a landmark statute in 1875. John Marshall Harlan for the Supreme Court recognized it in Neal versus Delaware. And what's true for the 15th is true for the 19th. Unfortunately, today's Supreme Court doesn't say stuff like that. It tends to focus on the Equal Protection Clause of the 14th Amendment rather than the 15th and 19th Amendments, and so much the worse for them.
Thank you very much, Professor Amar. All right, our panelists have rejoined us. If either of you would like to respond or have any comments.
Sure, I'd be glad to start. So thank you so much for those really helpful and interesting comments. The question of how the 15th Amendment was understood and how that should inform our understanding of the 19th is something I've been working through a lot with some of the scholars you mentioned, as well as others. And I absolutely see the arguments that you're making, but you know, you cited Professor Klarman perhaps as being on the wrong side, and I also in the paper cite Eric Foner, who agrees with Professor Klarman that there was a deliberate reason why office holding was removed from the 15th Amendment. I haven't done my own original, oh, you're on mute if you wanted to jump in. Still on mute.
I don't think that's my friend Eric's considered position after having read Vic's evidence. So I don't know if he.
Oh, you think he amended his?
I don't know if he actually. I don't know if he's even seen what Vic has had to say. But I didn't know that Eric had that view. He's one of my closer friends in the world, and I blurbed his books. He's blurbed mine. I bet in 5 minutes I will persuade him when I show him what Vic has found.
Well,
can I sit in on that conversation?
I would love to know what he thinks after he reads.
Yeah, I'm not going to contradict Eric Foner. But I'm pretty sure that Vic is, and I know Mike Klarman, I blurbed, you know, his Bancroft winning from Jim Crow to civil rights, but Mike is wrong. Mike doesn't even know what he doesn't know on this stuff, and Vic is, and I say that actually, and you were very nice to say I've been cited 36 times for the Supreme Court. It's actually 43, okay? And that's not true of my friend Mike Klarman, so I know what I know, and I'm really sure about this. And I'm sure I can persuade Eric Foner.
Well, I would, again, love to be part of that conversation if you could start it. Thank you.
Yes,
but my take on the 15th Amendment is more intended as context and background for the 19th. So while I'm absolutely very interested in that debate, what I would perhaps want to more emphasize is the relevance for the 19th Amendment. And I think we could at least agree there's an argument or an ambiguity about the 15th Amendment, which I find really interesting because it raises the question of, okay, well then if there was at least some uncertainty, why does it seem that no 19th Amendment proponent ever at the federal level seems to have suggested incorporating office holding into the text, just to, why not be clear? And in the meantime, I think at least 10, I'd have to look back at my footnotes, but at least 10 of the states in the 19-teens, late in the 1890s to 19-teens that adopted women's suffrage explicitly included the right to hold office in their state constitutional amendments. So at least, even if there is a very strong argument that office holding should be included along with suffrage, some people certainly didn't take that for granted. And that's really what I'm interested in.
I agree. And you could say that about just about anything. The 10th Amendment, you didn't have to say it, it's declaratory. Lots of things in the Constitution are declaratory. There's freedom of speech and debate even before, freedom of speech even before the First Amendment comes along. So yeah, you know, say it, belts and suspenders, but there was a reason, and this is what Eric may not actually have studied, there was a reason that people who were very emphatically pro political rights omitted it from the 15th Amendment because they took the position it went without saying, and if they said it, they're actually undercutting what they had done to Georgia. So
but the people who proposed it before it was cut out, presumably they thought it was doing something extra by having the word office holding, even though they didn't win.
So exactly so. So now the question isn't, you know, as a matter of logic, is there only one way to read it? And we have to choose, which is the better interpretation. But here's, just to repeat, what's really weird, it's in both the House and Senate versions. And then it's not in the conference committee version. So what's up with that?
Eric Foner says it's because the North wasn't going to ratify.
Well, as I said, I don't know if my friend Eric has actually read Alvin Stewart's autobiography. He's actually on the committee and has put it together with what happened in Georgia. That's actually the detective work that's at the heart of Vikram David Amar's piece, Jury Service as Political Participation Akin to Voting in the Cornell Law Review. That's actually what Klarman didn't know. And And Mike is a pretty good friend of mine, and I know that he didn't know this when he first started saying this. Earl Maltz didn't know this. I'm not sure if Eric Foner knew this. So now we have to choose. You're right. You could have said it, but by the way, you say, so now you say voting, but you don't say, and you say office holding. Oh, but you didn't say jury service. Oh, well now you say voting and office holding and jury service. Oh, but you don't say the right to be governor. Oh, now you say voting and office holding and jury service, but you don't say president. And is a president in office, and are legislative positions offices? So yeah.
And people debated all of these things.
You could always be more specific. But the question is, if you weren't more specific, what's the better interpretation?
And I prefer an interpretation that expands women's political rights for sure, and I think there's a strong argument. But the primary sources show that people were really unsure, and I appreciate your list of cases, some of which I dove into in the paper. But also, I think we need to look at state constitutional amendments and state attorneys' general opinions, because what's happening in the cases is just part of the story.
I agree. But one other thing I want to remind you of, a lot of times these are men who don't get it. And I know I've interrupted you 4 times, but I've interrupted you because I actually, care passionately about this issue. And I agree, because I've written on a lot of constitutional questions, and there's not a single one I've written on where someone couldn't say, it could have been more clear for your side. That's right. The question isn't, could it be more clear for my side? The question is, if I have to pick, which side actually does the evidence preponderate on? And that's ultimately a legal judgment in the end, and not even an historical judgment. It's how we do legal interpretation. So I say, that's what I do. And I do it, outside the 15th Amendment and the 19th Amendment. I do it for the first, and I do it for the second, and I do it for separation of powers, and I do it for federalism. So yeah, it's never 100-0. There are always people on both sides, and now you've got to figure out in the end, which is the better argument that makes more holistic sense of everything.
I just want to be invited to this conversation between you.
I will invite you. We'll do a Zoom with Eric.
I would love to let you and Eric talk about it.
We're happy to host it.
As long as I get invited. I want to thank you for your comments, because this is really useful to me. I'm not a legal scholar by any means. My father's the lawyer in the family, and so I always have to call him when I get a legal term, which I have no idea what it means, and ask him for it. But I'm going to be looking at these books because they're really interesting, and I think one of the things that you mentioned, that historians and legal scholars need to talk more. I think this is true. I mean, this is something I'm a firm believer in, because I think especially in our newfound focus, well, maybe that's newfound, but our recently revised focus on originalism, this becomes relevant, right? Because I understand that our sort of originalism is a sort of judicial philosophy, if you will, right? But it's not a historical one, right? It's historically problematic inherently. The concept of originalism doesn't work for most historians, I would argue, because the idea, first off, that there was an original intent is problematic, right? Because even our founding fathers, let's just go back to the original founding fathers, right? Even in their lifetimes, they're disagreeing on what they meant when they wrote the darn thing, right? And so when we look at it now, to me, I often see originalism, and I think someone asked in the question and answer, how does originalism view this? How might an originalist view the 15th and 19th Amendment? My sort of cynical answer, as the cynical historian that I am, I study lies for a living, so I'm pretty cynical in the way I approach the world. I'm an optimist in the rest of my life, don't worry. But when we sort of cynically look at it, my answer is however the hell they want to rule, right? If they want to overthrow something, they'll overthrow it, and then they'll find some justification, right? I'm very cynical in sort of how I approach this, because you can find the quotes from somebody in the Senate who says what one person says, and you can find someone else who's saying the opposite, and the question is, well, which did they choose? And the truth of the matter is, frequently there wasn't agreement on what it meant, right? Is that some people probably thought it was your interpretation, and some people thought it was your interpretation, right? And so that I wonder how much we're really disagreeing so much as we're finding the fact that when we look at legal sort of intent, there is creative misunderstanding, if you will, right? Is the only reason I'm going to vote for this is my understanding is A. And the only reason you're going to vote for this is your understanding is A is not the fact, right? And so we end up with something. And so how do you really, so this is the question I have, I guess, going back to both of you, I would pose it, sort of throwing it back is, how do we decide whose matters, whose opinion matters? And is it really and should we care? I mean, do I really want to care what somebody who died 200 years ago, enslaved people, didn't think women were equal, like, do I want to use their original intent? As a fundamental question. I mean, to me, originalism, if we're going to go down that route, my thought is maybe we should redraft the Constitution if we're going to go that way, because I'm not sure I want to know, I mean, what, Thomas Jefferson would think of the 19th Amendment. I don't expect it would be very good. And so I'm obviously with the 19th Amendment, you'd be looking at the people who passed the 19th Amendment. But again, here you have also, as the cynic, again, I'll just say one last thing and then hand it back to you guys. When they're looking at why are people voting yes or no at the state ratification level, if we want to know why people are ratifying it, I mean, some people are ratifying it because they think this is going to pass anyways, and if I don't ratify it, no woman's going to vote for me when the election comes up next year, and I want to get reelected. I mean, often I don't know that there is a well thought out legal understanding of what they're doing, as we like to preclude that they have some understanding of what this case will look like. They have a policy agenda that they want to see carried out. They don't necessarily have a constitutional philosophy they want to see carried out. And so that's where I'm sort of the cynic here. But I'm looking forward to reading these books, and I have to go to the library now. So thank you for the book recommendation. I'm looking forward to them.
So I have a thought, but I talked a lot, so I want to let Elizabeth get in first if she'd like, but I do have a response.
Good.
Oh, you can start.
Thanks. I've spent my whole life writing about these, and
right.
So two or three things. One, you gave the standard, anti-originalist argument number 3, but it's honestly not responsive to some of the things I said. I'm not giving you what one person said, although I do have Alvin Stewart, who was a guy on the committee, and is the only person who actually reported what happened in the committee. That's a very narrow kind of originalism. I'm saying Congress as a whole passed a statute, and the statute, when you look at its words, is actually word for word the 15th Amendment, but it's substituting jury service for voting, and my God, that's the gold standard. That's Congress, which is the body under Section 2 of the amendment that's tasked with implementing the amendment, telling you, here's what we think implementation is. And that's one of 2 congressional actions, not one guy giving a speech or in some sort of autobiography or something. The second one is Congress as a whole, not one guy tossing Georgia out on an express theory that you promised this and you didn't do this because they try to play Portia. They say, oh, we promised a pound of flesh, but not a drop of blood. We promised that we were going to let blacks vote, but not let them vote in a legislature or vote for blacks. So first, standard argument argument number 3 about originalism is in part about individuals and blah, 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 and motivation. And I'm saying, oh, it's so much better. And it rarely gets this good when you actually have 2 enactments of Congress as a whole that are directly connected to, the exact question that we want answered. So that's one thing. Second one is, motivations, maybe they're just proposing, voting for this to get women's votes and all the rest. Oh, I write in great detail about that, actually, in the books, and I agree with you. And I agree with you, it's deeply problematic that even the 19th Amendment, women aren't everywhere part of the process of voting for the 19th Amendment. If they already had the vote, they wouldn't need the 19th Amendment. So in some places, women, of course, already do have the vote, but in a whole bunch of places, it's men voting on whether women are getting the vote, which is why I'm actually, one of my additional reasons, in fact, I've got lots of people publicly, that's why this political cartoon, the cartoon says, women are too sentimental for jury duty, anti-suffrage argument. that cartoon has a whole logic to it. It's 1915, that if women get the vote, it will mean jury service. That's what Susan Glaspell is all about. I'm not saying one person, I'm saying that's the public discourse. But here's the problem. It's still overwhelmingly dominated by men, so I actually do think it's problematic to just pay attention to like original intent and all the rest, because this is intent that's way too male. Even the people implementing it, the judges and all the rest, or the state AGs, are overwhelmingly male. And these, for me, are, an historian doesn't play this game, but this is what I play every day as a law professor, legal arguments for why, at the end of the day, as long as I can find enough people who are legally competent at the time to take my broader view, I'm going to embrace the broader view. I'm going to say that's the better view. And finally, because it makes more sense of the Constitution as a whole, and that's the job of the interpreter and not just the maker, because people are adding text one by one by one, and they often don't sit back and say, how does this create separation of powers, federalism, checks and balances, 5 right to vote amendments that actually have to fit together, harmonious and all the rest. But it's not judges and interpreters making shit up. It's actually using certain legal tools of interpretation as to which history, you can call it original, is relevant, as well as text and harmony. Sorry, Elizabeth, I filibustered a little too much. My apologies to you.
No, that was helpful. I think especially what you were saying toward the end really captures part of, I think, why we approach the history in a slightly different way. Because my goal, at least in this paper, was not to say what's our best possible constitutional argument now, or how might a really excellent appellate lawyer use this history. My interest in the topic is more about, on the ground, what did people actually say? How did people at the state level, which is often overlooked, understand how the federal constitution related to their state laws, etc. Like, what did some state AG we've never even heard of before think the 19th Amendment meant? And that may or may not be relevant to creating a constitutional argument today about what the 19th Amendment should mean.
Right. But I would add to that, it does matter if we're trying to understand, say, Southern culture and Southern society in Tennessee, to know what the AG of Tennessee is saying. In other words, much of what Elizabeth and I are looking at is not meant in some ways to understand how we should rule in a case today, but understand what is going on with relations to gender and race in, or in my case, in sort of white supremacist rhetoric, to be honest, is what in many ways I study during this period and how it evolves, right? And in that way, it almost is irrelevant. It's not irrelevant in the sense of it matters when we go to the Supreme Court and have a disagreement, but it's almost irrelevant to the questions I'm asking, if you will. Although I'm now fascinated by it and looking forward to reading these books, there's no doubt, because I do think it will be interesting.
And history is almost always mixed. Almost always mixed. It is relevant to me, though, that I have lots of people on my side.
Right.
And now, actually, ultimately, these are a question of, and you're absolutely right, that, of course, the 19th Amendment is opposed in most of the Confederacy. Only 3 former Confederate states vote for it. You pick Tennessee for a reason, because that's the last state. And the South only begins to accept the concept of federal voting rights amendments, actually, with the 26th Amendment, the 18-year-old vote amendment. And because when you study 5 of them together, the 14th Amendment, Section 2, 15-1, 19-1, 24-1, 26-1, it's very interesting. Only in my lifetime does the South finally accept the concept of federal voting amendments, and they do it actually with the 18-year-old vote, and it's connected to the military and other things. And we haven't talked about military service. See, because Elizabeth, my position would be not just jury service, and not just legislative service, and not just appointed office holding and elective office holding, president or governor. It would be equal military service. So Roscoe versus Goldberg, in my view, is wrong. It's a violation of the 19th Amendment, plus the Second Amendment, to say that only male draft. The Second Amendment says your army, your military force, and your political body should be the same. The people and the militia should be one and the same. You shouldn't have a state within a state. So those who bear arms should vote, and those who vote should bear arms. And if that's true, and the 19th Amendment says, oh, women should vote, that means that she should bear arms equally too. Did some people say that? Yes. Did everyone understand that? Of course not. And a lot of the people voting are stupid men who don't get it.
I want to make sure we can get to a few questions from the audience members, because we are going to have to transition to the concluding program shortly. So let's turn to this. We have a question here. The 19th differs from the 15th in that there was no enforcement legislation promulgated pursuant to Section 2 after its ratification. So unlike the Force Acts pursuant to the Reconstruction Amendments that protected the right to hold office and jury service, there was no similar legislation, arguably for the same reasons, fear of a second Reconstruction on the part of Southern white congressmen and Alice Paul's continuing need for Southern congressional votes for her new amendment, the Equal Rights Amendment. What do the panelists think about how this historical development affected how the 19th has been lost to our collective memory?
That is a good question, and I don't know the background. As a memory historian, I'll start with this one. You know, one of the things about the whole force clause is that it hasn't it didn't always go enforced, right? I mean, I think this is an important thing, and I wonder, and I don't know, so somebody else hopefully will know, why there wasn't that discussion, as I've never looked at it. But I will say that it is worth noting that the force laws were, many of them were struck down, is my understanding eventually, right? Is that they aren't upheld, or at least parts of them aren't. You know, you have Crookshanks, and this is, of course, my, in one of the other questions that was asked earlier, or that I saw on the board, was about how does an originalist read the 19th, and sort of, you know, originalism versus this issue of originalism and how might the 19th be read today, someone asked. I don't remember exactly what the question was, but one of my fears going forward is that we could have a reading of these amendments that is restrained, much like the Crookshanks Amendment was for the 14th Amendment, that basically said, if an individual stands outside of a polling place and keeps you from voting, it's a state issue only, right? And that, of course, to me is the fear of the originalists, of the right. I'll say this: conservative originalism, which is, I think, probably a different form of originalism, perhaps, than we were talking about earlier. Is that you could go back to these older rulings that are inherently problematic. But I'm not a legal scholar, so I'll let the.
I have an endnote on this. It's endnote 14 at pages 589 to 590 of America's Unwritten Constitution. And there's a word that's still in the statute books today that really sticks in my throat. And it's the word male. And let me actually tell you, and this is connected to Adam's final comment in his presentation about Section 2 of the 14th Amendment that has the word male in it. I take the position that that word male has been superseded by the 19th Amendment, and Larry Tribe also takes that same position. Larry Tribe takes that position in his book, The Invisible Constitution, at pages 75 to 77. We're the only two scholars, actually, to really talk about that word male and whether it was implicitly, and Elizabeth, only implicitly, you see, it's all, and they could have said some more explicitly in the 19th Amendment, but they didn't. But we take the position, Larry and I, that the word male in Section 2 of the 14th Amendment has been superseded by the 19th. It means male and female. But here's the statute, that should any state, this is from 1872, should any state after the passage of this act deny or abridge the right of any of the male inhabitants of such a state, being 21 years of age and citizens of the United States, to vote in any election, blah, blah, blah. This shall be, okay. The current version, which is 2 USC Section 6, reads slightly differently, but still includes the word male, and that's an absolute disgrace.
Well, I'll just speak more generally to the question and about how the 19th Amendment is relatively overlooked or forgotten compared to the 15th and many others. And I would suggest that another reason for that is there haven't been nearly as many U.S. Supreme Court cases that prompt us to think about the 19th Amendment. So much of the action happened at the state level or didn't happen at all. So I'm really glad that with the Centennial, we've been getting a lot more attention to the 19th.
And I agree with Elizabeth completely. Her stuff focusing on states is really spectacularly important. You're absolutely right. Almost everything this is a Brandeisian point, almost everything in the federal Constitution, states did first. They had written constitutions first. They had written bills of rights first. They had bicameral legislatures first, and bills of rights that said freedom of speech and freedom of religion. And later on, women's suffrage, anti-slavery, women's suffrage. The states are where it's at. A lot of action, and I'm so glad that Elizabeth is doing very serious work. Looking at state attorneys general, state legislatures are jumping into the action in interesting ways, state court decisions, and they're all over the map. You're right, they're not all on one side. But when I read them, I actually say, oh, there are a bunch of people that sound a lot like me, they're getting it right. Oh, and then there are these men who just don't see it at all. They somehow say, oh, well, women have what it takes to vote, but they don't have what it takes to vote on a jury or vote. They have what it takes to vote in a referendum or an initiative, but they don't have what it takes to vote in a legislation. Well, how could that be? They're not thinking about how the Constitution fits as one whole thing. They don't get it.
I would want to add one last thing to that when it comes to the issue of memory. I think one reason we might not think of the 19th as much is because of where the focus has been on disenfranchisement. There has not been the same concerted effort since, let's say, 1940, to disenfranchise or keep disenfranchised people along gendered lines. The issue has been primarily along racial lines. That's where disenfranchisement has been aimed. Now, this raises an interesting question. As women increasingly vote for one party and not the other, which we're seeing a skew now, will we see something change by those forces in our country who have anti-democratic inclinations to hold on to power? I don't know. Are we going to start seeing women more, women's ballots being absentee ballots challenged at higher rates? I don't know, but we do know that how polling places are located. Also, you don't have the same, usually, at least not so blatant. You don't have the issue of redlining along gender. So you can't say, oh, this polling place, which is in an all-women's neighborhood, we're just going to have one voting machine. And in this other neighborhood where men vote, we're going to have 14 voting machines. That's much harder to do. It's much harder to target women than it is to target African Americans and other minorities when they want to vote. And so in some ways, not to say it's not important, but when we're talking about recent attempts to disenfranchise, I would argue that the 15th Amendment is in many ways central.
I want to make sure to do at least one more question from an audience member. And this one is from Carol Faulkner, who was one of our panelists earlier in the week. I wonder if the authors could talk about the connection between the perception of Reconstruction and Erupt and the power of political parties / election winners to distribute patronage positions in the 19th century, and how office holding and civil service was distinguished since women had access to some patronage and civil service positions in the 19th century as well. You have 4 minutes.
All right. You want to go first, Elizabeth, or do you want me to go first?
You can go first.
All right. So I'm going to do this as quick as I can, but I'm going to use an example that you're probably not expecting, and that is pensions. Because you thought I was going to go with government positions, but instead I'm going to go with Confederate pensions in the South. And there is an entire accessibility that is only available to white women and not really to black women to get pensions for Confederate service by their late husbands. And this is used as a form of patronage both for men and for women, these pensions. And what you see is that they are, and they are tied to Reconstruction specifically in the sense that they're the same people who are constantly talking about Reconstruction being corrupt and how we have to not allow Reconstruction to rehappen because of this corruption. At the same time, they're saying that they're literally making decisions on these pensions based on how somebody votes. So they're like, oh yeah, this guy was a deserter. He deserted from the Confederate Army, but we're going to give him a pension because he promises to vote the right way. And so the lies about Reconstruction are tied to lies about the present as well, right? And so I'm always focused on lies and corruption because that's what I'm interested in. But this memory of sort of corruption is ignores the fact that much of the much of the infrastructure around the lost cause was itself a form of corruption. And I didn't answer it nearly as well, but if you want to know more about pension fraud, in chapter 3 of the false cause, I extensively discuss it, and the way that this was also money only open to white women. So even as they're at the same time as they're opening up, white women are allowed to vote in the South, and black women are not, because they do keep black women disenfranchised. They're also giving money to white women, and black women have no access to this money because, of course, their husbands, if they were black, never served in the Confederate Army, because the Confederate Army did not include black men.
I'll just chime in quickly. So patronage politics is something that comes up frequently in discussions of women's suffrage in the 19th century. So women said one of the reasons they need to vote is so they would be given equal access to lucrative patronage posts, though there were some positions women had by the mid-19th century. For instance, women were postmistresses by the mid-19th century, and that was actually frequently referred to in state constitutional conventions and other contexts. My female postmistress is excellent, so why shouldn't we also let women be school superintendents and this and that? It was kind of a starting point for women proving their competency for similar kinds of offices. On the point of corruption, that also factored into some of the advocacy, not necessarily tied directly to Reconstruction, but the idea was, people said, women are more honest and they can clean up local government. And there was a very gendered argument of how women would fight back against corruption. And some people tried to tar anti-suffragists as trying to protect their corrupt government schemes. So both of those issues were prominent in suffrage conversations.
Thank you very much. All right. There are a lot of questions. I shall forward individual questions along to our panelists after the program is done, but we do have to move on to our concluding session here. So it's my pleasure to introduce you to two of the scholars who have helped put this program together. Christian Samito is lecturer in law at Boston University School of Law. In addition to teaching, he is a practicing attorney, public speaker, and writer. His areas of expertise include the legal as well as political, economic, military, and ethnic histories of the 18th and 19th centuries. His latest books are Becoming American Under Fire, Irish Americans, African Americans, and the Politics of Citizenship During the Civil War Era, and Lincoln and the 13th Amendment. And then we also have Allison Lange, who is Associate Professor of History at the Wentworth Institute of Technology, where students selected her for the Center for Diversity and Social Justice's Faculty Excellence Award in 2018. Her scholarship focuses on American women's history, specifically the suffrage movement. She recently published her book, Picturing Political Power, Images in the Women's Suffrage Movement, and she has curated exhibits on women's suffrage at the Schlesinger Library at Harvard University and the Massachusetts Historical Society. Allison and Christian, welcome back.
Hi, thank you so much for that lovely introduction, and thank you all so much for taking the time to be here today, taking the time out of, I'm sure, a busy Zoom schedule to talk about the 15th and 19th Amendments and how they came to be, but also the legacy of them. And so thank you so much to Kid and Katie for organizing this. We haven't seen much of Katie behind the scenes, but she's been also working really hard, and I want to appreciate both of their really important work during this conference. And also, of course, to Christian for being my non-MHS co-conspirator as we were working on organizing this conference. It's been a really wonderful, exciting week of amazing papers with terrific insights and really promising places for further consideration. And I hope that we will be able to have a chance in this strange Zoom world to have as much conversation as we can. And so the plan for this particular panel is for Christian and I just to say a few brief words. We're going to ask each other just a few questions. And also we're hoping to engage you all in the chat. So that we can have as much of a conversation as one can possibly hope for in a conference of this style. So please feel free to join us in the chat. We will do our best to kind of like keep up with it and bring up your comments, and hopefully this will be a really fruitful conversation as well as a concluding panel for this really excellent week of scholarship. So thank you all so much for participating. So this week we had a lot of different themes over the course of these several panels. You know, we started off thinking about updating biographies of voting rights leaders and really redefining who counts, who merits a biography. And I think that, you know, when we're thinking about that, you know, that's something that we're constantly seeing changing in 2020, particularly with regard to suffragists, where we're seeing this new rise of biographies that had never before been written, and it's very exciting to see those. We also thought about the ways that changes to voting rights seem to threaten the sanctity of marriage, you know, both with regards to the perceived threat of interracial marriage and changes in gender norms. We also looked at suffrage at the state, national, and empire level to see how the movement developed in different ways, in different places, and to really complicate this idea of one national narrative about women's voting rights. We also talked yesterday about the qualifications and the disqualifications for voting and the ways that voting rights activists, particularly women, challenge their position in American society while also reinforcing dominant ideas about who should have power based on things like inventiveness, mental capacity, age, and war participation. And today we had a really great conversation about the 15th and 19th Amendments, especially with regard to their legacy today. And I think that one of the things that stands out to me as part of this conference as a whole, but also as a more women's voting rights historian of the two, of Christian and I, one of the things that really stands out to me in this 2020 moment is that there is a major shift going on within women's suffrage history literature, which I think we're even questioning, do we want to keep that term suffrage because it is such so associated with white women's activism. And I think that one of the things we saw throughout this conversation this week is this emphasis on how race is played a really significant role in the advocacy of the amendments, in the passage of the amendments, and the legacy of the amendments in a real range of ways. And so I'm hoping that we certainly will with the questions that we put together. I hope in the chat as well to really grapple with how this literature is changing in many ways, but in particular in that way that has come up so many times over the course of this week. And I'm going to invite Christian to join me, and I'm going to hand it over to you to offer your insights on this week.
Thanks, Allison, and yes, thank you, Kid and Katie, for your work. It's been terrific. It's been a terrific week with great scholarship, great panels. Allison, it's been a lot of fun working with you on this. And I'd like to thank all the panelists and commentators who have joined us here today, because I've learned an awful lot and I've really enjoyed the conference as a whole. A couple of things really struck me. One is we have to recognize that we often encounter historical figures who could be egalitarian on one issue and not so egalitarian on another issue. We certainly encounter that with the suffrage movement, where we see, on one hand, we're talking about certain suffragists that had racist views. At the same time, we're talking about Black women suffragists and where they fit into the picture. I think we really highlighted the idea of giving fine-grained analyses that even on big political issues, right? It might be a constitutional amendment. We always think of that in terms of national issues, but local alliances, local rivalries affect those debates on a local level. We see that with, the suffrage movement for women. We see that in a racial context with, readjusters in Virginia, for example. I personally I really enjoy it and found it fascinating. All the papers that talked about the visual cultural politics of the suffrage movement. I'm always fascinated by the persuasive tools and arguments that people employ when seeking to change the constitutional order. So we, had a wonderful paper talking about suffragists cultivating the image of their reproductive and marital success, having baby pageants and putting together collages, literally collages of photos of their babies, and arguing that suffrage only enhanced domestic happiness. We saw, depictions of Lucretia Mott and Sojourner Truth showing these women as older. They weren't retouched photographs, but showing that these are older women. But in contrast to caricatures of, crazy old spinsters, right, that we would see in political cartoons and things like that to mock suffragists, here they're very dignified and very resolute. And changing the depictions of women in older age. And I especially liked also the paper about utilizing the record of women patent holders to show that women are able to invent, and thus they are able to have creative and independent thinking. So you have arguments about women being disabled from being able to vote. And then the record of thousands of patent holders explicitly showing their fitness to vote. And all of that reminded me of, in the 1850s, African Americans in the North using visual depictions of Black military service in the Revolutionary War and the War of 1812, and bringing out artifacts and talking about Crispus Attucks on an anniversary of the Boston Massacre. And then we see Cat using women's home front service during World War I to promote suffrage. So we see that. Also, it highlighted for me the importance of state initiatives and the role of federalism in constitutional change, right? We see women's suffrage in Western states before the 19th Amendment. We talked a little bit about state civil rights legislation after the Supreme Court found the Civil Rights Act of 1875 unconstitutional. So I think we sometimes forget how important historically state initiatives are. And it certainly takes place here with the women's suffrage movement.
Excellent. And I'd love to start us off with a question about the constitutional amendments for you. And if people in the audience want to chime in the chat, please do. We focus specifically on constitutional amendments in this conference, and we've seen a lot of myths right now about voting rights and the Constitution in popular media lately, including the idea that the 19th Amendment guaranteed the vote to women, that anyone is guaranteed the right to vote, in fact. Why do you think these myths exist and persist today around the 150th and 100th anniversaries of these amendments?
It's a great question. I think there's a lot of non-understanding about how voting rights actually work. And I think that a lot of people don't realize that voting isn't a right of citizenship, right? You're 17 years old, you're still a citizen, but you can't vote. And I don't think that people realize the extent to which states can regulate who can and cannot vote, right? It's why you had women's suffrage in the Western states before the 19th Amendment. In fact, the first big expansion in voting rights, eliminating property ownership for white men, happens on a state level after the War of 1812. So, to some extent, addressing voting in Section 2 of the 14th Amendment and then the 15th Amendment is a break from that. And it's why in various states, people who are under guardianship or people who are incarcerated due to a felony conviction can't vote. So the way it works is the 15th and 19th Amendments still allow states to regulate who gets to vote, but the states can exclude someone from voting on the basis of race or color or previous condition of servitude or sex. So to use an employment law example, if you're an at-will employee, your employer could fire you for any reason or even no reason at all, except for an impermissible one, right? Can't fire you because of your race or your ethnicity or things like that. Now, this leads to a lot of loopholes, right? Poll taxes, literacy tests, grandfather clauses that seem race neutral in their words, but not in their application. And they're used to exclude, black people from voting. Take the grandfather clause. It says that if your grandfather could vote, so could you, even if you didn't meet a certain test, a literacy test. So, white illiterate people will pass that, but black people in the South aren't going to be able to claim the same. I also think there's a lack of understanding about how federalism works. I think unfortunately, from my perspective as a constitutional historian, I think we've moved away from teaching about how the nuts and bolts of the Constitution works. I think that's why we have a political discourse on the level that it is. I think most people would be shocked to learn that constitutionally, state legislatures can decide how to determine the electors for the Electoral College. In Massachusetts and most other states, it's just simple legislation that says the electors are determined by whichever candidate wins the popular vote. That's how it is in Massachusetts, just simple statute. It's not in the state constitution or anything like that. Maine and Nebraska are a little different. They allow some of their electoral votes to be split by congressional district. But the legislature can decide. It would create a popular firestorm in any state, I'm sure, but under the Constitution, the legislature could say, we're taking that choice back. So I think that's what's going on. I don't think people fully understand. We use a lot of rhetoric without actually understanding, well, what does it mean in terms of the Constitution? Does everybody have the right to vote, et cetera, et cetera? And I don't think people understand federalism. It's complicated, and we do need a deeper understanding of this stuff, I think.
Right. I think that makes a lot of sense. I think the other thing we've noticed, even just over the course of this conference, besides this panel in particular, we've noticed a lot more focus in 2020 on the 19th Amendment is in terms of public programming and documentaries and exhibitions and quite frankly, a lot of books too, a lot by people who are here today. Why do you think that's the case? What is it about the 15th Amendment that doesn't kind of create the same kinds of attention and conversations as the 19th?
That's another great question. I think part of it is because women's suffrage is such a long movement, right? The Declaration of Sentiments in 1848 talks about suffrage, and you fast forward 70 years and you're still having that discussion. So there's a lot of history there, but it's a history that hasn't gotten the attention that it deserves. And I think, this anniversary has been a very obvious and natural moment to start changing that. I think we've started doing that with this conference and some really thought-provoking presentations. But you're right, it was heavily weighted on 19th Amendment. Even the proposals we got, almost all of them were 19th Amendment. On the other hand, I think that because the 15th Amendment is part of the much larger history of Reconstruction, it's something so complicated, has so many moving parts. And I think the 15th Amendment and the 13th Amendment, frankly, get short shrift. I think there's so much attention on the 14th Amendment and then other things that are going on in Reconstruction that the 15th gets a little lost in the bigger story. And then finally, I think it's because the 15th has both a short and a very long story. On one hand, and I think this is an amazing point, right? It takes place within a few years of abolishing slavery, which I think is a pretty profound thing, right? It's not all that long after Dred Scott when you think about it, right? And it gets passed pretty easily in the Congress and pretty easy ratifications in the states. But I also say it's such a long story because there's such a painful aftermath to it, right? On one hand, you get these great moments of Black people voting, serving in office, both local offices as well as serving in Congress. People thinking equality has been achieved because Black men could vote. But then you have the KKK, you have other white counter-revolutionaries committing unspeakable acts, you have poll taxes and literacy tests. And for me, I don't think you could talk about the 15th Amendment without talking about that really painful arc, right? You get this great constitutional change in the law, but this violent counter-revolution in practice. So I don't think it has a very celebratory feel to it in a way. right? I mean, it's ratified in 1870, and almost 100 years later, we're ratifying the 24th Amendment to eliminate poll taxes, the Voting Rights of 1965. So I think in some respects, it's a chapter in this much bigger arc, and it is a little hard to celebrate it because you commemorate it, but it's hard to celebrate it because you know that there are all these other components, and some of them are pretty disheartening. But yeah, I've noticed. I mean, I have myself many more books and things on the 14th Amendment. One of the Civil War journals published recently a dedicated issue on the 14th Amendment. You don't see that for the 15th. I mean, actually, it struck me. I think they published it this year. I think it was there this year, and I remember thinking, that's pretty interesting. We're getting a special issue on the 14th Amendment the year that's the 150th anniversary of the 15th. I'd like to ask you a few questions, if I may, and one of them that came to mind is, how do we reconcile the racism of certain suffragists with commemoration of their activism?
That's a question that I think a lot of scholars and public historians, historical institutions have really been grappling with this year. And people have done it in different ways. You know, we've definitely seen one end of the spectrum being incredibly celebratory, you know, saying that women were guaranteed the right to vote with the passage of the 19th Amendment, and that kind of really superficial kind of celebration of the passage of the 19th Amendment. But we've also seen a really much more critical evaluation of the amendment, as you suggest, you know, with the 15th Amendment, you know, looking at it as a broader expansion of voting rights. I think that a lot of people who study the history of women's voting rights this year are also aiming to put the 19th Amendment in exactly that same spot. So thinking about it as a milestone, as a significant moment, but by no means the end of the story. You know, by no means should we celebrate this as the final victory for women in politics. And I think when we think about the suffragists themselves and how they used racism, how many of them used racism as a political tool, as a strategy in order to win over supporters, I think we need to grapple with that, recognize that as, for many of them, a really essential part of their strategy. And I also think that it's really important for us to both, you know, not just think about the suffragists in this way, but also historical figures in general. I think that 2020 is this moment where we are looking at the people who once perhaps many saw as, you know, unblemished historical figures, and wondering, do we want a statue of Thomas Jefferson? Do we want, you know, how much do we, have, this adulation for George Washington? Is that, he's a complicated figure, just as someone like Elizabeth Cady Stanton, just as someone like Alice Paul, all of them, all of these as examples of people who used race, racism, white supremacy in order to advance their own agendas. And so I think that we need to really develop, nationally, really, a better way, a more shared way of recognizing that these really important historical figures did very important things, even though, in addition to the fact that they held these really horrible views that we strongly disagree with today. I think that we just have to hold those together and find a way to both critically analyze those racist strategies, as well as recognizing the contributions that they did make. And I think that the question is really important because it has this division among white suffragists and suffragists of color, from the 19th century is still kind of part of our scholarly literature in a really meaningful way. You know, for many years, it was very possible to write about the history of women's suffrage without talking about the National Association of Colored Women. And I think in the last, recently, we've seen a lot more shift into, taking an organization like that one, just as an example, more seriously within the so-called like suffrage literature, right? Like there are plenty of Black women's political books on women in politics that have for many years taken the National Association of Colored Women and other organizations like that very seriously. But I think we're finally, I hope seeing these two, for reasons, for reasons that are really deeply historical, these previously separate literatures coming together. And I'm really optimistic that in the future we'll have just a greater, broader history of women's voting rights that is still very much in progress, like right at this moment. I just received Kathleen Cahill's book in the mail, Recasting the Vote, and I think that that's very much in that vein. So yeah, that's a really important question.
And I think that actually goes to the first question you asked me, why there's such a focus right now on the 19th. And I think part of it is because there is so much exciting scholarship that's coming out. This is in process and in progress. One other question I want to ask you is, as someone who's been involved in observing all these 19th Amendment commemorations, what's stood out to you about them? And do you think historians have, changed the popular narrative in this process?
That's a really great question. And this is something that I really hope that we'll see some comments in the chat about, what has stood out to you about centennial commemorations throughout this year. And I think that one of the things that stood out to me is kind of like part of the same question here. I have been impressed by just how much of the scholarship that so many of us have been working on has become part of the popular narrative, very much so in things like exhibitions, an exhibition at the National Portrait Gallery, which featured a really extraordinary number of portraits of women of color, things like the New York Times section on suffrage, which a lot of suffrage historians participated in, and we were able to see in a way that's far more accessible than any kind of journal compilation, the various directions that so many of us are going right now, which I think is very exciting. And I do think, I maybe am offering a more optimistic view, I do think that people like Mary Church Terrell, for the first time I saw this past year, I can't remember the precise date of Mary Church Terrell's birthday, but I suddenly saw on social media all these kind of commemorations to her birthday, and Fannie Lou Hamer's birthday more recently. And so I think that these names are becoming slightly more familiar, and that in itself is to me very exciting and hopeful that all the work that so many of us have been doing is really making a difference in popular conversations.
Yeah, and I also, I think, you and I have talked about this. Originally this conference was supposed to be live, and that was with a little bit of trepidation, this idea of moving it online. And frankly, I looked at it as a blessing, because not all that many people are going to, fly to Boston if you're somewhere else in the country or abroad. And now people are able to attend conferences like this from wherever they are. So I think that's been actually probably a help. If anything's good come out of this really terrible situation, and it's making this stuff more accessible, right? People could be anywhere in the country and able to attend conferences like this and to learn. Whereas before, it was on a more narrow level of professional historians and law professors going to conferences and not being able to have that wider engagement.
Yeah, I mean, I think that one thing I'm hoping that we'll see as a result of both this centennial moment and this pandemic moment is a book that really grapples with how did the 1918 flu pandemic affect the suffrage movement? You know, I've done a little bit of research on it. I have
I think you have your next book.
rough understanding, but someone I know will be doing that. I think it, you know, my little bit of research has shown me that, you know, September 30th, Woodrow Wilson addresses the Senate, urging them to, you know, to approve of the 19th Amendment. Within the week, DC is hit hard, and everything pretty much falls apart for a moment. And I think we can relate to that in a way that we probably couldn't relate to that 10 years ago.
Oh,
And
do
so,
that book, Allison. That would actually be a great. I think that's your next book.
yeah, maybe so, or someone in the audience's next book. That would also be fantastic. So the next question I have is, you know, to you and our audience, you know, what's one theme that really stood out to you from this series of panels? Is there, you know, or is there a particular one thing that perhaps you're taking away as we move forward, as we close out this conference?
Yeah, for me, it's what I said earlier. What really struck me are some of the vehicles used to persuade. What are some of the vehicles that are used to, you know, persuade, to oppose opposition viewpoints, right? And that's something that always fascinates me. How do you get constitutional change affected? Whether it's, you know, casting yourself as the conservative, right? American revolutionaries would have said, you know, look, it's Britain that's out of whack. We're trying to preserve the constitutional order. You know, or Lincoln, who, you know, Cooper Union is saying, look, I'm just comporting with the founders. Whether it's African Americans, you know, saying, you know, look, we participated, we voted in constitutional, we fought in the Revolution War of 1812. For me, it really struck me. Not just that women had to make these arguments, but how they crafted them, right? How they used patent holding, which is something I wouldn't have thought about, patent holding to counter the concept that they, you know, weren't able to vote. They couldn't be independent and creative thinkers to vote. And then some of the popular you know, issues of having to show, look, we're suffragists, we want the vote, but we're also, you know, happy wives, and we're good moms, and we're, you know, having babies and doing that side of things. I found that absolutely fascinating, and gave me a lot to think about.
I so appreciate, as a visual culture scholar, that you found the visual culture.
I figured you liked that.
I agree. I really enjoyed seeing the new directions in that work as well. It's very exciting. I think that for me, one of the things that I really enjoy, especially since my research on suffrage has been so much about national public conversations, it often misses the nitty gritty of, you know, how things are happening on the ground in a lot of different places. I really appreciated some of the takes, you know, the looks at, you know, Oklahoma and the Philippines. I really appreciated the ways that I gained a much better understanding, a much broader understanding of this, you know, kind of more abstract national movement. I really appreciated the new ways that, the new places that we're thinking to look as well.
Yeah, I think so often we look at things on a national level and we forget that you have local dynamics, local politics, local dynamics, local personalities, local alliances, and rival. That all factors in, and could have a national impact. Yeah.
Yeah, exactly. So I think our final question, and you know, if anyone else has questions they'd like to put in the chat, feel free to do so. You know, we learned a lot of amazing new research, new ideas to think through, and I'm wondering, you know, they point to some really exciting new directions, and I'm wondering if you have ideas of where you would like to see the research go. I know that we have some undergraduates and graduate students watching, participating, as well as scholars working on their next projects. You know, what kinds of things do you see coming down the line?
I want to see more done with how law, society, and politics intermix. I think that's something that people sometimes forget. Especially now, we often have this vision of law being the province of court cases, and in reality, it is all intermixed. And every 4 years, we have this discussion, and we realize that. And then I really want to see people look from a historical perspective how law, society, politics intermix, as well as how law affects real lives. I mean, I think that's another one of the reasons why I enjoyed so much looking at learning about the baby pageants and things like that. That legal change affects real lives. It's very easy to be a law professor and look at the 15th Amendment and talk about constitutional doctrine and all that, but we sometimes forget the people that poured their heart and soul into promoting that issue, and then the black men, and then women who get to cast that ballot for the first time, and what are they thinking, and how are they finding this newfound power? What are they saying about it? What are their anticipations? How do they think life is going to change going forward because now they've been enfranchised? So I'd really like to see more of that. We talk a lot about getting to the amendment. What about the aftermath? What happens? Now, for African Americans, there's a lot more scholarship already done on that, at least in certain areas, looking at, KKK, what does this all mean? Black office holding, but then also opposing. I'd love to see that done with the 19th Amendment. What did it actually mean? What was the state of women and voting and politics in 1925 or during the Great Depression? What was going on the World War II moment? Not all that much time passes, right? I mean, we're talking, 20 years. That's historical. That's very short amount of time. What's going on with that? I'd love to see that kind of follow through on the aftermath of the 19th Amendment.
Yeah, and I think we are seeing just a start of that, and I hope that we'll continue to see that. I think for me, I would just reiterate what I have mentioned previously, which is, I hope that we're starting to think even more broadly than outside of the constraints that the term suffrage, the women's suffrage movement, really has for so long constrained us to. Outside of the people, outside of the organizations, outside of the timeline. And I think we are seeing that. And I will be so interested to see, if this literature, on more broadly women's voting rights activism does emerge. And I'm very, very excited to watch that happen. Perhaps we'll have some fabulous new synthesis of the amazing scholarship coming out around the 19th Amendment that will do just that. So we will see. It looks like we have one comment. So we would like to see women's suffrage in a larger context, a foundation of American narrative that addresses racial equality. To be specific, this person would like to see more scholarship on the intersection of race and gender. And, I think I agree with you, Bibi. I think that this is something that is a possibility. I think we can have, one of the books that we were mentioning earlier in the other panel was Alexander Keesar's book, which is kind of this big book on voting rights in the United States. Will there be a big book on women's voting rights in the United States? It just really specifically focuses on how that evolved over time, a big synthesis. I think that there's a place for that. And by thinking about women's voting rights, I do mean including that intersection of race and class and so many other citizenship questions that go along with that.
Yeah, I always think there's, you get Alexander, his book is but you can always have additional syntheses. And I think as new scholarship and new angles develop, and it doesn't mean that the old synthesis is, now gone, but you add more synthetic works aside it to. So I think that's probably coming. I mean, I think that's one of the things that we're seeing develop. Possibly even some of our panelists, are thinking ahead of some of that. Hopefully. hopefully that's
Certainly, yes. It's not to diminish his work at all. I cannot tell you how many times I have picked it up over the last several years. So that's certainly true.
Yeah, it doesn't diminish the work of great syntheses that are the go-to book on something to add, other ones that look from a different lens or combination of lenses. It enhances the story. I think it gets back to what you were talking about. History is complicated. And I think that we have to understand that and embrace it and explore it. And, I always tell my students when we're reading, frankly, some tough things, because I get into a lot of these issues and I tell them that some of this reading is really tough. I've read it 30, 40 times, the KKK hearings. I cringe, even though I know word for word what's coming. But we have to look at this as historians and figure it out and understand it. So we know our past and how we got to where we are and make decisions about our future. Yeah.
That's a good message to end on. Although we're not ending, I will just remind people that this is only the end of the first part of the conference. The panels, Alex Kesar is actually the moderator of our panel, which we hope to have in person at the MHS. Come one, come all. We're going to have a great party when we can actually get back together again. Allison Parker at the University of Delaware and Lisa Tetrell at Carnegie Mellon are going to get into a conversation about this moment. So this is an ongoing conversation. We have not set a date yet for that, but we will certainly make sure people are invited. So this is just the beginning. And like most conferences, we certainly hope to see a whole lot of wonderful scholarship come out of this. So thank you to Christian, thank you to Allison, thank you to Akhil, to Adam, to Elizabeth for concluding today. And on behalf of the Massachusetts Historical Society, thank you, our attendees, for joining us this week. And we hope to see you in safer and healthier and happier times at 1154 Boylston.